What would you like?
So Judge, two things. I've talked to Madam Prosecutor on this case, Judge, and I'm approaching on two things. One, bond reinstatement and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge. Right.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide.
Traveler. Okay.
During the stop.
We open in court. The defense asks the judge for two things: to hear probable cause and to reinstate bond. Right away, you can feel the tension. The lawyer is calm but deliberate, trying to reset the case. This opening sets the stakes. Is the court going to give the defendant another chance or tighten the screws? Reaction. This is the classic do-over moment in criminal cases. The lawyer pushing for procedure, the court weighing safety. Engagement question. If you were the judge, would you hear the PC first or decide the bond issue immediately?
The defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what.
So we looked at, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're just trying to get him out of the car.
I don't disagree.
It's classic sovereign.
The prosecutor lays out the stop. Harris County officers pulled the car for a fake plate reading traveler. The defendant refused to provide ID or insurance and said, "I do not consent." Officers tried to remove him and alleged he actively resisted. That short scene is loaded. Refusal to ID, a strange plate, a physical scuffle. Reaction. Red flags everywhere. A fake plate, refusal to identify, and physical resistance. Those are precisely the ingredients that push a routine stop into a criminal arrest. Engagement question. Do you think refusing to show ID should be treated as a crime? Why or why not?
Case where got the license plate, think that traveling by right is what I think how they term it.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
But he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where
Defense counters. Interference with duties of a public servant might be charged, but my client didn't really interfere with his own arrest. He was trying to protect himself. The lawyer references a sovereign-style argument about traveling by right. That language betrays a legal theory some defendants use to avoid traffic laws. Reaction. This is where law meets online ideology. The courtroom isn't a forum for internet sovereign theories. It's about statutes and safety. Transition. Next, watch how both sides use the video as a weapon.
officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
We don't disagree, Your Honor.
Right. You know what I mean? That's real life.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know. Did you hear that on the video? Right. And so
both sides and the judge talk about the video. Defense says officers were pulling and tugging and that his client feared for his safety because multiple officers were present. The prosecutor and judge note the speed and brusqueness of the interaction. The video becomes the key piece of truth and also of interpretation. Reaction. Videos don't speak for themselves. People interpret them. Is the video evidence of unlawful force or proof of resistance? That split determines everything. Engagement question. What matters more to you? The officer's force or the defendant's refusal? Tell us why.
Reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally
Remember,
not.
this is, for now, this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
you know, they ask you to come out of the car one time. Yeah, you know, it's really, that's, so, I mean, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond. Your bond is set at 2501, and you've continually failed to appear. So, you know,
The judge leans toward probable cause. There's enough to go forward. But bond becomes the real battleground. The judge points out an existing $251 bond and the defendant's repeated failures to appear. The tone shifts. We move from facts to the defendant's pattern of behavior. Reaction: judges don't like being ignored. Miss court dates, and you lose the court's sympathy fast. No dramatic legal theories will rescue you from repeated no-shows. Transition. Now the courtroom turns to the defendant's life and perspective.
the case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that? How do we deal with that, Timberland?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure.
Defense makes a plea for context. The defendant is a working Black man unfamiliar with the court system. Maybe he reacted out of fear, not malice. The lawyer even references family experience with police to explain what basic training looks like. This is the humanizing moment. The legal chessboard meets real life. Reaction. The lawyer's point lands emotionally. People raised outside the system can legitimately fear police, especially given the current climate. But sympathy doesn't erase the alleged acts. Engagement question. Should courts weigh a defendant's familiarity with the justice system during sentencing or bond decisions?
It's common knowledge is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do come in contact with police, and my mother is assistant chief of police. So I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up, what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration, number one, from his perspective, all defendants can't just say this, but I do see that,
The defense asks for the PR bond to be reinstated and promises the client will comply. The lawyer vows to be tight and reachable, basically promising the court they won't waste its time again. The judge is skeptical but listening. This is the pivotal negotiation: trust versus track record. Reaction: promises matter, but past behavior matters more. The judge wants assurance that the defendant won't play games. That's the real currency in these hearings. Transition. The judge's instructions are about to get very specific.
From what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case. What you know about me, I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. I promise you. I don't care whoever you have if you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? I mean, when you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
Not right now.
You're not.
Judge issues a blunt warning. The defendant must not drive, don't get into the driver's seat, and must stay in contact with his attorney. The judge emphasizes consequences. Miss court again or get arrested for something else and all bets are off. The tone is stern and practical. Reaction. This is courtroom pragmatism. Conditions are set to protect the public and compel compliance. It's a reminder that liberty often comes wrapped in strict rules. Engagement question. Would you accept strict bond conditions if they meant staying out of jail? Why or why not?
Not allowed to drive.
Right.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberly, I'll
you.
reinstate the bond.
Thank you, Your Honor. And I'll talk to her. We were going to try to talk to Chief, but it's pretty busy today.
Here's the short legal summary. Officers stopped a vehicle for a fictitious plate. The defendant refused to ID and allegedly resisted removal from the car. The judge found probable cause to proceed, but after hearing the defense's contextual plea and the lawyer's assurances, reinstated the PR bond with strict conditions. No driving, remain in contact with counsel, and show up to court as required. The ruling balances procedural rights, a chance to be represented and heard, with accountability, conditions, and warnings. Broadly, the case highlights 3 big issues: the power imbalance in traffic stops, how online sovereign arguments spill into real courts, and how courts handle defendants who claim fear or unfamiliarity with the system. If this courtroom exchange made you think, hit like, share your view in the comments. Who do you think was in the wrong? And subscribe for more courtroom breakdowns, true crime analysis, and legal explainers. Turn on notifications so you don't miss the next breakdown where we analyze the video evidence and legal arguments more closely. Thanks for watching. See you in the next one.